Welcome to the Illinois Divorce Guide podcast, where we break down the complex and emotional process of divorce into manageable, easy-to-understand steps. I'm your host, Greer Howard, and with me is Bobby Buchanan, widely recognized as one of Illinois' top divorce attorneys, offering unmatched insight and experience in family law. Well, Bobby, we are back today for another topic, marital versus non-marital property. And this is a big thing that people think about when they're going through divorce because they want to know, how are you going to kind of separate everything that you've accumulated during your marriage? So why don't we just sort of start out? Can you explain marital versus non-marital property?
Absolutely, Greer. It's great to be back to do another episode. And this is a really good one because we're diving into, we've done financial considerations before, previous episode. Today is really getting technical. Marital versus non-marital property, what that really means. So when we get divorced, one of the biggest steps, really, it's two parts: figure out what's going on with the kids and then figure out what's going on with the property. The property aspect, the first step is classifying property. What is marital and what is non-marital? And what that really means is, what are we going to divide and what are we not going to divide? We don't divide non-marital property. You're going to keep all of your non-marital property. Your spouse is going to keep all of their non-marital property. And then we're going to divide marital property. So that's like the basic difference between the two.
Okay, so let's talk about maybe some examples. So for instance, if someone was to, let's say, inherit some money during the marriage, is that always considered non-marital property?
Yes. The short answer is inheritance is always considered non-marital as long as the person that has passed it along to you has specifically made you and only you the heir of that property. But let's back up a little bit and give kind of a general definition. So in general, non-marital property is everything that you came into the marriage with. And marital property is going to be everything that you and your spouse acquired during the marriage. So, for example, your paycheck is non-marital before you got married, and you put your paycheck in a savings account or a checking account. It just had your name on it. And then you get married, your paycheck is now marital property. So your paycheck is something that really, it changes classification entirely when you do get married. And then there's other common assets in a marriage that you start to acquire during your marriage. Retirement accounts, maybe you buy a house, you buy a car. And we should clarify that when we say property, we're not just talking about things you acquire, assets. We're also talking about debt. So credit card debt is also something we need to classify and figure out, is it non-marital or is it marital?
Yeah. Okay. So you mentioned for instance, the paycheck, and I like that example of your paycheck before you got married is non-marital, but then it becomes marital once you are married. So maybe what would be some other examples? What about like retirement accounts or maybe a home that you own? I think those are big things that people think about. If they had purchased that, if they had started saving for retirement or purchased the home before they were married, is that considered non-marital?
Yes. So the home is one that we often litigate or really need to negotiate around when we do a divorce, especially if it was purchased before the marriage. So let's say I go into my marriage, I've already purchased a home, it only has my name on it. At that point, even when I get married, that home stays non-marital. Even if my spouse moves into the house, we raise a family, it's going to continue to be non-marital. Now, the complication becomes if we're paying a mortgage and that mortgage is being paid from marital funds. And let's be honest, most of the time it is, because your paycheck is now marital. So as most of us do, we get paid and then we pay our mortgage. So now you're making marital contributions to a non-marital property. So it gets a little bit muddy there. And the same thing goes for your 401k or any retirement vehicle where you contribute to it. you contributed a bunch before you got married, and now you continue to contribute to it after you're married. So there's going to be some mixing there, and the waters are going to become muddy as well. So that's when it becomes a little bit more technical, a little bit more gray as far as, is this marital, is this non-marital?
And would you say that typically the longer that you're married, the more that non-marital property almost starts to like shift to become more marital property? Does that make sense?
Yeah, absolutely. And yes, I totally agree with that assessment. When we have these marriages that are 30, 40 years, even less, maybe 20, there's been so much mixing of marital and non-marital property that it's really hard for the court to distinguish those. And in most of those cases, we're not talking about, should this be classified as marital or should this be classified as non-marital? We're talking about, how should it be divided? And that's what kind of the second step of this whole formula is. First, classification, and then once we've classified it, how are we dividing it?
Yeah. Okay. So let's dig into that. So equitable division. So, how are we going to divide everything equitably? So if you know that you have your marital and non-marital property, so how is the state of Illinois going to kind of consider those things during a divorce?
Yeah, like you said, equitable division. That's the catchphrase. That's the key thing that people need to know. If you have a friend in California and you've heard about their divorce and they talked about the property division in their divorce, don't make the mistake of assuming it's going to be the same, because California is a community property state. It's a different sort of division that happens. Community property, and again, don't quote me on this, I'm not the California expert, but it's really more 50-50 down the line. In an equitable division state like Illinois, it's all about it being fair, but not necessarily equal. And let me remind you and the viewers, what we're talking about is dividing marital property. We don't divide the non-marital, we just divide the marital.
The marital. Okay. So let's dig into that. I feel like this is a phrase we need to really dig into. So fair, but not equal.
Yes.
So you mentioned that. What exactly does that look like? And how does the court decide what's fair?
It's not always easy, and the court uses a multiple factor test. It's not, in legal terms, this is not a bright line rule. It's not like, okay, if these things are met, then this one spouse gets 25% and the other spouse gets 75%. It's a pretty loose, factor-driven decision that gives a lot of discretion to the judge. And what I mean by factors is the judge is going to look at, what's the current financial status of the parties? How much is each party making? What are their actual incomes, their salary? What's the potential for them to make in the future? What has been the lifestyle of the parties? There is a bunch of different factors that the court is going to look at to decide what is equitable. That being said, in probably 90% of cases, judges go with 50-50. So you really have to show the court a compelling case as to why it should not be 50-50. Contributions to the marriage is another big factor. And we don't just mean financial contributions. We mean possibly you're a homemaker and you have done a lot of work in the home to just make it a beautiful home, to sustain the home, and then to raise the kids. Courts will look at that and say, you are absolutely entitled to 50%. Now, I should give you the caveat as well of, people sometimes come to us and they say, well, my spouse, they didn't do much as a homemaker. I was building my career. I was working my butt off. I was bringing home all this money, and they weren't really doing anything at home. That argument, unfortunately, isn't going to get you that far. Being a homemaker, it's not a very high bar. So I would just presume that if the property is marital, you are probably going to have to split it 50-50. That's like the presumption. Now we can deviate one way or the other, but don't think just because you were the career person and your spouse was not, that you're going to somehow get a bigger chunk of the pie. It's usually the opposite, actually.
Right. Okay. And I mean, that makes me think. So you're saying, this is like you're kind of talking about the home and it being 50-50. And obviously the couple is trying to get divorced. So they're not going to like split the house and, in half and live on either side. So does that sort of look like maybe pulling out the money and kind of as far as the asset, and then somebody potentially maybe keeping the home and the other person, being able to take some of the value of the home? Is that sort of what that ends up looking like?
Yeah, so we got to figure out what's the exact mechanism. Like you said, it doesn't make any sense to bring out the chainsaw and split the house down the middle. Or, we don't want to be roommates and live together forever. So how do we actually split the home? The two most common ways that we're going to split the home are either a cash out refinance. So the party that stays in the house is able to refinance it and pull out at least half of the equity. Let's assume there's $500,000 of equity. We go to the bank and we say, okay, we want to cash out refi and pull out $250K, and then we give that to the other side. If that's not a possibility, or it just doesn't make sense in the situation, both parties don't agree to do it that way, then the other mechanism is we're going to sell the house. And so that selling the house, we do need to figure out some of the logistics of that. Who's going to be our real estate agent? What offers are we going to take or not take? And then how exactly we're going to divide the proceeds. But selling the house is a very common method of resolving the issue.
Sure. And, what about other, assets of high value, for instance, like a 401k? How does the court sort of decide on that? You'd kind of mentioned or alluded to earlier that if you'd started a 401k, before you were married, that amount is non-marital, but the time that you were married, how does the court sort of see that part?
Yeah, so 401k is one of the most common assets that has two classifications, where the court is very comfortable saying, okay, this amount is non-marital and this other amount is marital. And the way that they do it, it is a formula where we look at what was the non-marital balance and then what were the contributions after the marriage. We do have to take in consideration what is the increase in value of the 401k during its lifetime, because the non-marital portion of the 401k also increased in value. So it's not as simple as just saying, okay, what's the total balance today minus the balance when we got married? Like that formula wouldn't work. So it's a little bit more complex than that. But there is a formula, and once the court decides, okay, here's the marital portion, it's divided 50-50 in 95% of cases. And the way that we actually do it is this special order. I don't want to get too technical here, but we do something called a qualified domestic relations order. And that is a special court order that the judge signs that we send into the 401k company, Fidelity or whoever it may be. And it gives them permission to open up a second 401k for your spouse and push the money in there that they're entitled to. So we can all make it happen. The best way for people to think about this is, let's decide on what we want to do over the dinner table. Don't worry about the details of like, how do we get this done? That's what the lawyers are for. We know all those little technical tricks in order to make it happen. So I'd say start high level when you're thinking about the property issues and figure out what you think is fair with your spouse. Leave it to the lawyers to actually make it happen.
Yeah, that makes a lot of sense. And what about, I imagine with a lot of these assets, over time, they start to like commingle, and maybe the classification of the marital versus non-marital property sort of starts to blur a little bit. So I'd love to talk a little bit about that. What happens when the two start to mix?
Yeah, when they do start to mix or commingle, as you said, which is the term you might hear in court, as you start to deal with this stuff. When they do commingle, which is the 401, for example, the 401k example, your paycheck, which is now marital, is going to, and part of it is going to go to your 401k. Well, you are commingling two types of assets. You're commingling the non-marital portion and the marital. So when that happens, you are muddying the waters. And if you muddy the waters too much, then what's going to happen is the property is going to change into a different classification. Now, we get around that with the 401k because an important part of commingling and making sure that commingling doesn't lead to, and I don't want to, again, throw too many technical words in here, but lead to transmutation, which is the word we use to say, okay, something went from non-marital to marital. To make sure that commingling doesn't turn into transmutation, we need to be able to trace the funds. We need to be able to clearly show with evidence, with bank statements, with receipts, invoices, whatever the case may be, what is non-marital and what is marital. So with a 401k, that's relatively easy to do. There's established case law on making that happen. With something like a mortgage, or let's say you do renovations to your house, that's a little bit more difficult. You redo your kitchen and of a non-marital residence, but you redid it with marital funds. And then that kitchen led to an increase in value in the house overall. It starts to get really tricky to say, well, how much of that increase in value is due to the market, due to the renovation, due to both, due to the marital, the non-marital parts? Judges at that point go, you know what? This is enough commingling that this entire house is transmutated into marital property. So people have to be very careful in what's happening with their assets once they're married, because things can change.
And it makes me think about the inheritance question too. So earlier we talked about, if you had gotten inheritance that was non-marital, but I'm sure there's probably instances where that inheritance does become marital property, depending on how you use it, right?
Yeah, how you use it, what you do with it. So if I get an inheritance of $500,000 and I don't know how I'm supposed to handle it or don't know the implications of it, and I put it into the joint checking account or the joint savings account, just that act alone could make it so that I have to split that inheritance when I get divorced. So literally just depositing a check could make it so you lose $250,000. Now, these things aren't easy. There's no reason you'd really know this or think about this in the normal course of your marriage. There's not a marriage, when we get married, there's not a waiver that we sign that says, I understand all of these things about how my property is going to be treated. So we're looking at this stuff in hindsight. I will say that the one or two ways to not look at this in hindsight would either be using a prenuptial or a postnuptial agreement. So that's something for people to be aware of. If you are listening to this and you are thinking about divorce, but maybe not, maybe you still want to save your marriage, or you think there's hope to doing that, but you want to, maybe clarify these property issues, talking to a lawyer about a postnuptial agreement might be a great idea. A postnuptial agreement is where we sit down, we discuss our property, we discuss what should be marital and non-marital, and we actually sign off on it during the marriage, and then we don't have to answer these questions when we get divorced.
Well, it sounds like there are certain actions during a marriage that can actually change the classification of marital versus non-marital property. And you mentioned this term called transmutation. So, and that's what it is. So can you sort of dive into that and give us some examples?
Yeah, absolutely. Transmutation talks about that transition from non-marital into marital property. And what the court is going to look at is there or was there an intent to treat a non-marital piece of property as marital? So a very black and white sort of situation is when someone has a house, it's just their name on the deed, and then they put their their spouse's name on the deed as well during the marriage. That's pretty cut and dry. That property has been transmutated, changed into marital property. Another example that could be a little bit more gray would be extensive renovation. So let's say they did more than just the kitchen, but they started renovating all aspects of the house, and before you know it, there's not even a single piece of wood that's the same on the house from when it was non-marital. At that point, it has transmutated. It doesn't have to be as extreme as that, but if you are doing these extensive renovations and really investing your time and your labor and your money into this non-marital piece of property, but with marital time, money, and labor, that's where transmutation can come into play as well. So you do have to be careful. And again, we're talking about this in hindsight. It's probably too late for you at this point, but these are the things that we're going to look at to figure out how we're going to classify your property.
Yeah. And are there ways that if you have something that is non-marital property, is there certain things you can do to make sure that it stays that way?
Yeah, absolutely. The first one is something I just alluded to, which is the prenuptial or postnuptial agreement, which can be a great tool to use, the postnuptial agreement. A lot of people do that. The most common time that we see postnuptial agreements are either when there's a big transition, lifestyle transition in a marriage. So, for example, I did one where the parties were going to move internationally, and I think it was my client was taking this important international job. It was this huge commitment for the entire family to move to Europe, and the wife wanted a little bit more certainty on, well, what if this doesn't work out? What am I looking at during divorce? So we did a postnuptial agreement. Another time where it's not uncommon is if there's some infidelity and the parties want to still, the party that was cheated on doesn't want to try to save the marriage and then get the short end of the stick. So if I'm the breadwinner and I get cheated on, and I say, okay, I'm willing to work at this. Let's see if we can get past this. What if 10 years down the road, I find out that my spouse has continued to be unfaithful? And then it's like, okay, now we're going to get a divorce, but we've tried at this for 10 years. And now she or he is even more entitled to all of my hard work while they were stabbing me in the back for the last 10 years. Like, that's not fair. So we can put in writing what is going to be marital, non-marital, what's going to happen in the case of divorce. So that postnuptial agreement and prenuptial agreement is a great tool. The other way that we can protect our property is being careful of what we do with it and making sure that if we are making money moves, that it's very clear where that money is going, and we're able to basically extract it out by using those statements and those receipts. And it's because we have to show the court by clear and convincing evidence, and that's a very high standard, that it is non-marital property. Once the court will presume that property is marital if there's an allegation that it is. So
that makes me think on the inheritance side of things. Is there a way for the family member who's leaving the inheritance to put in writing or to say, hey, this is just for this one person? Like, it is not marital. It is for the one half of the couple.
Yeah. A best practice is definitely for them to be very clear in their instrument, in their will or trust. And then once I do take that inheritance, it's up to me to make sure I'm not putting it in a joint account. Because once I put it in a joint account,
then you're commingling.
Then I'm commingling.
Yeah.
And it doesn't matter what the heir or what, my mom or dad put in their will.
Right.
I've already taken and done something with it. Now, there are more technical instruments that could be used. There could be certain kind of trusts and foundations that can be set up. But, at that point, if you have those types of assets or those types of concerns, go see a divorce attorney or an estate planning attorney and they can really dive in and show you what needs to happen.
Okay. Well, a lot of interesting things today. What an interesting discussion. And, for the takeaways for our viewers today, what do you want to make sure that they're going home with?
I want people to understand that if the property is marital, most likely you're going to have to divide it 50-50. If you're on the side where you think that the other, like, hey, I worked so hard, I don't think the other side should get 50%, you're probably going to be on the losing side of that argument. I'm just going to tell you flat out that that's going to be a tough argument to make in court. There are exceptions. Please talk to a lawyer if you want to dive into those. But usually it's the homemaker, it's the one that sacrificed their career that is going to get a larger percentage. That's where the better argument is. The better argument is if you're on the side of being the homemaker who doesn't have a great upside or future potential to make money, then you have an argument to say, I should get 60, 70, 75% of all the marital property because it's my spouse who is going to be making more and more money as they continue up the career ladder. So just keep that in mind. Don't get caught in this delusion that you're somehow going to convince the court that equitable division is some sort of 80-20 split or something like that.
Yeah. And I'm going to lead the charge. I think that, people need to be having these conversations before they even get married. It's unbelievable that you can actually get married and not, have something from the court to say, hey, by the way, these are the things you should be thinking about because we don't want to see you back here.
Yeah, absolutely. Without a doubt. There should be that waiver that we sign when we get married to understand what we're giving up, what our rights, what our responsibilities are, but there's not. So
that's
getting
so
educated
interesting.
that way. Yep.
All right. Well, Bobby, thanks as always for being here with me today and having this discussion about marital and non-marital property. And our next discussion, we're actually going to go through some questions. So stick with us for next time because next time we'll sort of go through some questions from our viewers about this very topic. Thank you for listening to the Illinois Divorce Guide podcast. We hope today's episode gave you clarity and support as you move forward on your journey. If you found this episode helpful, please subscribe, rate, and review us on your favorite podcast platform. Tune in next week for more insights and expert advice on the Illinois Divorce Guide podcast.